Hello and welcome to GDPR for Business. I'm Dan Hyde, a partner at Harrison Clark Rickaby's, a leading technology law firm specializing in all manner of tech regulation. Today I'm going to be speaking to Sam Thomas. Sam's a barrister. He sits on the IT panel of the Bar Council, and he's also written some of the leading books on crypto, blockchain, and cybersecurity regulation, law and practice. Sam, that's right, I think, isn't it?
Well, you know that's right, Dan, because you co-wrote the books with me. Cybersecurity, Law and Practice, and Blockchain and Cryptocurrency, International Legal and Regulatory Challenges, which I think is a pithy title that you came up with.
Yeah, I think that trips off the tongue nicely and
Absolutely.
something that anyone can remember. Let's start, Sam, with just explaining for those who maybe don't have a full grasp of what data protection is and what the GDPR actually regulates.
Well, GDPR stands for General Data Protection Regulation, and it's been around for a long time now. But people don't really grasp that it's about personal data and what personal data really encompasses.
Yeah. So my understanding of personal data is it literally has to be personal and that it's capable of identifying a person. But what that means in practice, it may not just be information or the written or the typed word, but it could be an image, it could be a body part, effectively anything that's capable of showing the person behind the image or the person behind the word.
I think it's important as well to highlight that it's a person, not a company, and a living person as well. For example, I did a case in which there was a complaint about someone who had unfortunately died. Well, GDPR just doesn't cover that.
Let's just have a look at some examples of what might be capable of being personal information. So I think a face perhaps might be capable, but then if you start to look down, what about an earlobe?
Well, again, it sounds a bit ridiculous, but is in fact something that I've dealt with. A face can identify a person, but what about a close-up picture of an eye? If you've got an optometrist who has a picture, an OCT scan of an eye, can that actually identify an individual or not? And that's a balancing exercise, because in certain circumstances it can, maybe the earlobe can't, but maybe teeth or eyes possibly could.
Yeah, I mean, I should have thought the question's going to be is whether there's uniqueness. So, is an eye akin to a fingerprint unique enough so that it can only be attributed to a single person, and then you've got personal information. So those are the sorts of kind of interesting questions people ought to be asking. First of all, to see whether they're even going to be caught by GDPR.
Absolutely, because once you know that you have personal data, then there's a lot of duties and responsibilities that are incumbent upon you. So, for example, you have to identify the reason that you are holding that personal data.
So this is your lawful basis, if you like.
Absolutely right. Once you've identified you have personal data, you have to identify the reason, the lawful reason, and the lawful method that you have for holding that data. And if you can't, well then, why are you holding it? You should really be getting rid of it.
So again, just to help people, so the first step is, am I actually holding or dealing with personal data?
Yeah.
And if I am, you're then looking to say, okay, what's the basis that I'm hanging on to this or dealing with it?
What's the purpose? Yeah.
What's the purpose? So the sorts of purposes that would be or might be lawful, can you give us some examples of those?
If you are holding it for a particular reason, for a necessary reason for business or commercial purposes, that would be why you are holding it.
Yeah.
Or, for example, if it was patient records, again, another example going back to my own practice, individuals, optometrists, doctors, dentists will hold information because it's necessary to maintain their health records, to maintain their health, and that would be a purpose for holding the information.
So that's in furtherance, if you like, of their business or occupation. I mean, another example would be where you have consent. I mean, let me just try this on you, Sam. I hope you understand how knock-knock jokes work. Knock-knock.
Who's there?
GDPR.
GDPR who?
Do you have my consent for that information? It's a silly joke, but the point is...
It's a very dad joke. It's so good. Yeah.
They're my favourite ones, yeah. But it basically is a good example of how another lawful reason for holding something would be if you had the consent of somebody. But again, presumably you'd have to be able to demonstrate or prove that you had consent.
I think what you've got to do is you've got to consider the two things, not simultaneously, but you have to consider the two things. Why am I holding data?
Yeah.
And then how am I lawfully holding that data? So what is the reason for me to hold on to it? And then what method have I got? What lawful purpose have I got for holding on to it? So consent could be a good one. Consent is consumer has said to you, you can hold on to my information because I want to hear about marketing. Yeah. Patient says, you can hold on to my health records because I want you to look after my health. And you've got to remember with consent that it's proactive. You've got to opt in. It's not a matter of opting out.
Yeah. I mean, the other point that flows from that as well is what's the consent for? So when you're looking at the purpose, what did they consent to? Because it could be that you're actually using their data for something that they actually have no expectation of. So again, I suppose if you're a business looking at this, you've got to take a long, hard look and say, okay, I got consent, but is what I'm doing with this information in line or in line with the expectation of the person who gave the consent in the first place?
Absolutely right. And be proactive. Think about what you want consent for and then ask for it at the outset. Because once you've got consent, it's not really possible to go back and change it unless you want to go through the whole process again.
I mean, the other interesting one that I always come up against from businesses who are looking to see what they can and can't do is the arguments of, commerciality, commercial interest. We need this information and we need to be able to process it because that's how our business runs. What would your comment be on which side of the line people should be when they're relying on, if you like, the commercial interest in order to process information?
Well, there are two things there that you can really consider because there are a number of lawful ways to deal with data. We've mentioned consent, but that's not the only one. People get very fixated and focused on that. Contract, you could contract into the use of data. So that might be where you could do something commercial.
If the contract actually gives you the right to handle or you need it to fulfill the contract.
Absolutely right. Or there's something called legitimate interest. And that would be that it's in the interest of both parties or one of the parties that has a legitimate interest to deal with the personal data in a particular way. For example, again, an example going back into my experience, if you've got someone who has come up to you and said, I want to use an individual's data, I know that you have it, can I use it? Well, if the person there, the data processor or the data controller is holding on to that data and knows that the other person would like it to be used, well, then they can pass it on without their consent, as long as they know that it's a legitimate interest for all parties.
Yeah. I think another important point to make here as well is when you're looking at, say, legitimate interests or looking at your interest as a business, you've got to be very careful that you don't forget to balance that against the interests of the person whose personal information is, if you like, the data subject. So there's a balancing act that goes on because your use of the information may adversely impact on the person whose information it is. So you've got to make sure that you're looking at the, if you like, the impact that your use is going to have, even if it's to further your business.
Now, one thing I think is really important and we have to think about now is the rights that individuals have over their personal data. And the one that I think we've got to talk about now, because it's going to lead into some of the other topics we're going to talk about, is the right to be forgotten. What do you understand to be the right to be forgotten to be?
I understand the right to be forgotten is basically if you're holding my personal information, I have the right to say to you, I'd like to have that deleted. I don't want you to have that anymore.
Yeah.
Is that correct?
That's pretty much it. Data should be deleted after a period of time anyway, because after a period of time it becomes useless and consequently should be discarded. Properly discarded, not just thrown in a rubbish bin, but properly deleted. Yeah. But then there's an additional right for an individual to say, actually, I don't want you to wait until that time period's up. I want you to get rid of it now.
I mean, I think another thing just to raise at this point, so anybody listening will understand, is there are principles flowing through the GDPR. We talked about, for example, lawfulness. So, what lawful right do you have to use this information? But then the other side of that, of course, is principles, and that deals with how you're actually going to process or deal with the information. So principles would include what we call de minimis. So, taking the least amount of information you need, holding it for minimum amounts of time, only using it for the limited purposes that you've got consent for. And I guess all of that, again, ties into the right to be forgotten when somebody says to you, I don't want you to hold this information anymore.
And the other principle, and it's a sort of secondary principle, is security by design. So the idea that your processes, the way that you're incorporating the de minimis and the necessary, has to be designed into the system in which you're holding the personal data.
Let's say a small business who might not have sophisticated systems or a whole IT department to deal with this. I mean, how would they go about having that sort of security by design theme?
Well, when you say security by design, people might automatically think about artificial intelligence or quantum computing or blockchain. But actually, design can mean just a policy or
Just
procedure.
you've thought about it was what I, yeah.
Yeah, absolutely. It's not necessarily automatically about a technological advancement. It's about that you have a policy or procedure which is relevant to the personal data. For example, I've got a small company that I'm working for at the moment. They have to put in place a policy which says after X number of years, in this case, it was 10, after 10 years, we will delete the data. Now, that's a straightforward policy, but it's secured by design. After 10 years, they're just getting rid of that information. It can no longer be accessed.
That's a regular theme flowing through my experience as well. I mean, often clients will say, what can we hold? How long can we hold it? Or, should it all be here, there, or in another place? So there's quite a lot of juggling goes on to see what can be kept, what should be thrown away, and where what's being retained should even be kept, so that only those that should have access are able to access it.
But that's the basic. And we've written 2 books about cybersecurity and about blockchain.
Yeah.
And so we don't really want to just talk about the basics. We want to talk about the future.
Yeah.
And in particular, I thought we wanted to talk about blockchain.
So Sam, you've mentioned blockchain, which obviously is really important here, but I suspect it's such a big topic that maybe we pick that up in another of our chats.
Such a big topic, we wrote a book about it. So
you love the plugs, don't you?
I do.
I mean, let's move to perhaps the international dimension of GDPR, because what strikes me is when it came in from Europe, the idea was that it was going to be some homogenized, if you like, global piece of legislation that all the countries would adhere to, so that if you're in a business, it wouldn't matter which country you're dealing with, you'd have the same rules that apply to personal information. But of course, that never happened. And I think it's important for anyone to understand that really what we're talking about is from a European and a UK perspective. And it doesn't necessarily apply to certainly countries such as the US, which has a slightly different approach, or certainly a different approach depending on which state you're dealing with, because you have state set laws there. Russia is a very different system entirely, because Russia, like China, for example, you have the state itself, the government, as, if you like, the ultimate interest in terms of personal data and what we might call personal data sovereignty. So I think maybe we should give a thought to any business listening of the sort of examples where they might be cautious when they're dealing with, say, a business that might be overseas.
Well, when the European Union drafted the legislation, and this is a European Union focused regulation, they drafted it in such a way that it wasn't just Europe or now the UK, it was any country or company that was using personal data from an individual within Europe. So if you were selling into Europe, for example, from Australia, then you would have to consider GDPR and you'd have to be GDPR compliant. The problem with that, of course, is, well, how do you enforce it? If you're North Korea and you're misusing personal data from a French citizen, what are the European Union going to actually do about it? And I know that sounds like a stupid example, but when you've got a country like the US who are dealing with personal data of European citizens, but perhaps don't want to use the same regulation that is being enforced in the European Union, well, what do? And there is a big conflict about that. It's quite an academic conflict, and maybe we're not going to get into it here, but you've got to consider the international aspect. But actually, the international aspect doesn't cover what perhaps the European Union hoped.
I think one point that we must emphasize, and this is something that obviously comes up a lot of the time when I'm dealing with companies trying to work out their problems, is the test, or the litmus test, if you like, of whether on paper at least you're caught by the GDPR, is whose personal information is. Because if it's personal information of a European citizen, if I put it that way, then you're supposedly within the GDPR framework. Yep. And that surprises a lot of businesses, because they think, well, hang on, this isn't a European issue, or this isn't a UK matter. But that's not the test. The test is basically, if you treat the information as belonging to a person and the person is within the UK or Europe, then you're caught. And as we said, the practical problem is when you're then transferring to maybe other businesses in another jurisdiction, looking to see, does the GDPR apply? But also then, am I safe to make the transfer? What What other laws am I dealing with? How can I transfer it across to, say, Russia or China?
And it's really, what sort of business do you want to be? Do you want to be the rogue state business who doesn't care about GDPR? Or do you want to be the conscientious GDPR compliant business? Because, of course, there's commercial advantages to that. Because if you can say, well, I am GDPR compliant, well, then you can sell into Europe. And, of course, you've got a much bigger market there in which you are able to sell your products or sell your services.
Another point I think worth raising at this juncture, because when we're also talking about the international piece or moving information around, what we're really looking at there is risk. So what's the risk of somebody's personal information being accessed or used when they haven't consented, or in a way that they didn't foresee? The other thing that people often don't associate with the GDPR is cybersecurity, but that's also, if you like, the other side of the data protection coin.
Mm-hmm.
As I say, the two are sort of inextricably linked in a way. And GDPR itself doesn't just deal with data. It also puts an onus on the business to make sure, for example, that there are adequate technical measures in place and that there are also adequate organizational measures in place for keeping the data secure. So what you're looking at there is it's basically cybersecurity kit, and then cybersecurity culture to make sure that you're actually complying with the act and looking after the data that you've been entrusted to look after.
Well, we've already touched on secure by design. Your systems must be secure by design. And we've touched on whether that's just a basic procedure or something a bit more technically advanced. But it's difficult to conceive of a cybersecurity breach. So a hacker, for example, stealing data from a company, and that not also being a GDPR breach. Yeah. Because the definition of personal data is so large that it's potentially going to include, or does include, credit card details, financial information.
Yeah.
It's highly unlikely that a cybersecurity breach is also not going to be a breach of GDPR.
Yeah. I mean, the example that I always come across there from businesses is they sort of say to me, well, hang on a minute then, how can we protect ourselves? What's meant by adequate? If I've got to have adequate tech and if I've got to have adequate organizational systems, how high is the bar? My advice to them is usually adequate is taken within context. So, adequate for a 2-man, 3-man small company working out of a back bedroom wouldn't be the same as it might be for, a big blue chip global company who've got deep pockets and lots of money to spend and a lot more risk and traffic flow.
And that's absolutely right, Dan. If I was dealing, in my experience, with a large multinational company, which is across a number of jurisdictions, well, then they need an internal IT team to ensure that their cybersecurity is being dealt with in-house. But if I'm dealing with an individual entrepreneur, that's just not possible. It's unreasonable, and consequently, it's inappropriate and not necessary.
Absolutely. Understood. So to sum up, Sam, we've talked about data protection. We've explained what GDPR is and what its scope, what its reach is, and we've looked at the end also at cybersecurity and how that is important too within the data protection context. I guess the takeaways for business leaders would be, what do you think the key takeaways, if we could distill the advice down to them?
Do you have personal data? Why do you have personal data? How am I protecting that personal data? And because if you don't know what those things are, you could be in real trouble. And the fines that the ICO can hand out are massive.
Yeah. And the fines, it's not just the fines, it's also the reputational damage and all the other piece that comes with that, not least potentially an action being brought by data subjects who discover that you're in trouble with the regulator and decide they're going to go after you as well.
So we can talk about the best way to protect that data in another chat.
We certainly can. So thanks for listening. Please tune in again to listen to Sam and I discuss these topics around cyber, blockchain, and the tech advantages and disadvantages within business. Thank you, Sam, for your time today, and goodbye, everyone.